Hi,
Hey,
Doreen.
I'm Doreen.
Hi, I'm Mohena Singh.
Welcome to Hall on Estates. You're listening to episode number, what number are we on, Mohena?
637.
Great. Today we'll be discussing the dependent support case in Nanchin and Peller. It's a recent case of the Ontario Superior Court of Justice. Mohena, do you want to give us a bit of the context for this case?
Yeah,
Or the
sure.
facts?
Yep, sure. So this was a motion for interim dependent support under the Succession Law Reform Act. And in this motion, the applicant was the girlfriend of the deceased, and the respondents were the siblings of the deceased. And the applicant was seeking to be considered a dependent of the deceased and the dependent of the estate. And she also said that the deceased failed to make adequate provision out of the estate for her support. So she was bringing this motion to receive interim dependent support from the estate.
Yeah, and this one, the whole inadequacy stems from the fact that Jeffrey died intestate. He died on November 9th, 2001, and the claimant is his girlfriend at the time. He was not married to the claimant, but he was actually married to a previous spouse that he was separated from, but had not finished his FLA divorce proceedings with. And so under the rules of an intestacy, you still have a married spouse. This is someone who died in 2001 before the new rules kicked in. He has siblings that are the other named respondents in the proceeding. And so this is where you get this cast of characters. And I think you can get a sense of, where the meaty issue is going to be when you have a common law spouse, you have an intestate estate. Any opportunity for somebody to fight against a dependent support claim, a lot of times that stems and starts from, do you qualify to apply for dependent support in the first place? Are you a spouse as defined under the Act? Because if you're not, even if you get nothing, well, you're still gonna get nothing from the courts, because our legislation is very clear that we are using the same definition of spouse as it exists under the Family Law Act, under Section 29 of the Family Law Act, and for those who do not actually have children together, so common law spouses without a child that they treat as their own together have to be continuously cohabiting together for at least 3 years before death in the SLRA context. So this is really where the rubber hits the road, and this is where you get sort of the competing factual evidence. Obviously the claimant's going to say we have been together, we are spouses under the proper definition under the law, and we have been for more than 3 years, thus I'm entitled to support. You get one story from the applicant. And then here in this case, you get obviously a different story from the estate as well as from the ex-wife. So Mohena, why don't you tell us a little bit about the claimant story?
For sure. So Tiffany argued that she had started living with the deceased from September 2018. So they lived together on a rural farm property. And up until the deceased passed away, which was November 9th, 2021, as you mentioned, they were also engaged to be married. So their engagement took place in February of 2020. And to support her story, she had filed affidavits from various witnesses, such as the deceased sister, her friends, and some farm veterinarian that would come to the farm. And she also presented documentary evidence of a TD bank statement that showed that her address was at the farm. So that was really her main argument, was that she was living from September 2018, and that would have been the 3 years.
Right. And how that really differs, at least in this record, in this case, as it relates to the ex-wife's evidence, is that, as I mentioned before, the deceased was in the middle of an FLA proceeding. He had not, come to the conclusion with a separation agreement. They had not been divorced yet. And in all of those materials, the agreed upon date for when him and his ex-wife, when they were sort of like last able to reconcile their separation date. Well, their separation date happens to be after the date that the applicant claims that she started cohabiting with the deceased. And it is a date in March 2019, which, because of death in November 2021, brings it into the less than 3 years category. And so this is where you really have this just like a really big chronological disjunct that at the end of the day really hurt the applicant. Like, it actually killed her case, because she was saying, no, we were together cohabiting for no less than 3 years. It started September 2018, but all the materials in the divorce proceeding said their separation date wasn't until March 2019, bringing it into the less than 3 years bucket. And then the court actually had to reconcile this, all of this, like, conflicting pieces of evidence, all of these issues of credibility in a case that was put forward without any cross-examination on the affidavits. And there was no viva voce evidence either, because this is a motion. So the court was left to answer these like really big questions. Does this person even qualify for support under the SLRA? You have all this like conflicting factual evidence. There are issues of credibility, because it all comes down to what this woman is saying about, the duration and nature of her relationship with the deceased. And all you have are pieces of paper that, don't add up to like one cohesive story. And at the end of the day, just as Conan said, the burden is on the applicant to prove and make out her claims. And she wasn't actually able to do that and overcome her evidentiary burden here by presenting enough that would actually like ameliorate and sort of like explain away all of the other points that are contrary to her case. And it falls on that basis, which is really unfortunate. I think this one, you didn't even get into like the typical legal analysis of, is this person like a common law spouse under the FLA, and have that test be used under the SLRA, like the 7 Milotovich factors. We're here, you're really actually just stuck on this like chronological difference. And if you don't qualify in time, well, the nature of your relationship, you don't really need to like get into all of that, because even a common law spouse for 2 years, the legislation says like that's too bad unless you actually have kids. So in this case, it just really seems like quite unfortunate. And I think as a cynical litigator, sometimes these separation dates, people fight, quite a bit in the context of a divorce as to like when you would actually have the date. And sometimes one of the parties are going to want that date to be as late in time as possible, because if you're dividing assets of a marriage, things tend to be worth more, like as current as you are in time, right? The later the V-Day tends to be, the assets will, tend to be higher, especially if you have real property involved. So like some of that like push and pull and, her evidence about when they actually physically start living together, it just seems like maybe had there actually been like a full trial on this issue, I just can't help but wonder like how different all of the evidence would end up being, which is again too bad. And had she been married, well, then she's in a completely different boat. She would have her rights under intestacy. She would actually be a beneficiary, and then it would be whether or not her preferential share would be sufficient. And actually in this case, if he didn't actually have kids, well, again, very, 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 very different story. She would actually, have the whole estate on an intestacy had they been married. But you can't get married if he hasn't, divorced his ex-spouse. So yeah, unfortunately, like these scenarios you do see, like it's not uncommon, sort of like that gap in between relationships when things are like actually really a bit more like messy. So we're all just human beings, you know, like we've all gone through breakups, people get back together, new relationships start. But when, you know, when do like these legal rights like end and start for like, you know, all those that are involved? And, you know, when the judge has to be the one to really decide, like, when does something like start and end? And this is what you see on the face of this decision, you know, when all you have are kind of at the end of the day affidavits telling competing stories. What can you really do with that? And here I think Justice Conant really did actually just repeatedly say, had this been like a trial of evidence, even had there been any like cross examinations, anything that really tested like the credibility of the applicant and when did like the relationship really started, you know, the court sympathies like may have just really like say gone another way.
Right.
But yeah, this is a very interesting case. I had mentioned that I think like the more like classic legal analysis of common law spouses under section 29 of the FLA are those like Milotovich factors, which you don't actually like see in this decision, but Milotovich factors are still being used in our SRR cases today, even though it's a case from the 1980s, so actually from 40 years ago. And those 7 factors are shelter, sexual and personal behavior, services to each other, social factors, societal factors, whether or not there's any economic, so like financial support to each other, and children. But again, the court didn't get into it here because you really just actually have to get into the realm of those 3 years before someone would actually consider whether or not the quality of the relationship, say quality in quotes, would actually fit under the definition. Yeah, be interesting to see if this is the end of this case, if there ends up being any appeals. I don't know.
Yeah. So what would be the next step, Doreen, since this was the motion for interim support?
Well, I think like that finding that she is not a spouse, you know, be at like an interim stage if you're not a spouse, because they didn't actually get into whether or not she has any need for support. The test for interim support is whether or not you're in need of and entitled to. And so if you're not entitled to, just because you don't fit in the definition, you know, that's why I didn't really even get into like any consideration of need, because to be entitled, even at first instance, you have to be a qualified person under the act to claim for support. Otherwise, like, you're not a person that actually has this cause of action, right?
Right.
So yeah,
It's
too bad.
Yeah. No, that's great. It's a very interesting case because, like you mentioned, we're trying to put very determinative dates on something that's very fluid, which are relationships. So it's an interesting one.
Yeah, and it's just one where, like, you know, after like a full trial, could it be that, you know, despite the fact that there is still a little bit of an overlap in like the two relationships, does that really sort of like change where they were at, and like sort of like maybe when like the legal factors around those like 7 factors that I talked about would have actually like started, you know?
Right.
So
Yeah,
tough to say this one.
for sure.
Well, thanks, Mohena. That concludes our podcast. Until next time, we want to thank you for listening. I'm Doreen.
I'm Mohena Singh.
Should you have any questions, please email us at info@hollandhealth.com or contact us through the contact page on our website.
Nice. Thanks, Doreen.
Thanks. Bye.
Bye.